Good night. This is U.S. Immigration Attorney Sharifa Tharpe. I am here live to take your questions. Go ahead and put your questions in the comments so that I may answer your questions. So I am going to come with a new approach tonight. Thanks so much for the love. I just want to get your questions tonight. I don't have a specific topic, but your questions are going to guide the conversation tonight. So I want to hear your questions. Go ahead and put your questions in the comments and I will go ahead and answer your questions. So I am going to, while I wait for your questions to come in, I'm going to tell you how to get in touch with me if you want personal legal advice. Thanks again for the love. I appreciate it. But the focus tonight is really going to be your questions. It can be anything that's immigration related. And let me tell you, if you have that question, then many others have the same question as you. And so by asking your question, you are helping me to give you information you and others care about. So go ahead and put your questions in the comments. Now, if you would like to get in touch with me to schedule a consultation, you can go to the link in my bio. And when you get there, you're going to see different ways to get in touch. And all of those ways are going to lead to a scheduling coordinator. The scheduling coordinator is the person who is in charge of scheduling those consultations. And the only way to get to speak with me is in a consultation, in a scheduled consultation. You can call. The numbers all over my videos, and it's on the website. You can fill out a contact form, and it will, if it's after hours, like now, today's a holiday, so the scheduling coordinators are out. However, they will be back tomorrow, 9:30 a.m. to 11 p.m. as usual. And if you want to call now, a representative after hours receptionist will answer and take your name, your information, and then the scheduling coordinator will get right on it tomorrow to schedule your appointment. So I see some questions. This is great. Let me go ahead and read those questions out and then answer. So can you talk about sponsoring a spouse if you have a green card, please? And thanks. So Caring with Cordisha, thank you for that question. Now, if you are a permanent resident, you can surely apply for your spouse. However, the way that the process is going to go is going to depend on whether your spouse is here in the U.S. or if they're outside of the United States. If they're outside of the United States and they don't have any other disqualifying issues going on, any past criminal issues, any past immigration violations, any past deportations, as well as other red flags I'm not touching on, that's where the consultation is very important. Then it's just a matter of filing the petition. Once it's approved, it's taking about a year for that I-130 petition to be approved. Once it's approved, it goes to the National Visa Center, which serves as like the middleman between you and your spouse and the U.S. Embassy. The National Visa Center, for example, when I represent my clients, I work with the National Visa Center to make sure that all the requested documentation is in. And then once it is in, they go ahead and schedule that appointment. Now, Caring with Cordisha, what I want to let you know right now is that there is no wait list for residents to apply for their spouse. That's because there's no wait list for the immigrant visa number. So it's going on the same timeline as it would if you were a U.S. citizen sponsoring your spouse. So it's taking about 18 to 24 months, which is the same as if a U.S. citizen was sponsoring their spouse. That will not last. As soon as more applications go in and those applications outnumber the number of immigrant visa numbers available, then there's gonna start to be a wait list and it's gonna go for years. So if you are thinking about sponsoring your spouse, be sure to schedule a consultation and get on it right away so that you can start, your process can get into motion and not be held back by a wait list. Now, if your spouse is here in the United States, you're going to want to be more cautious, of course, because if they're out of status, they will not qualify to apply for permanent residence here. If they're in status and they're going to be in status for, you know, the next 2 years while the process is pending, that's great. Then they are likely to qualify for adjustment of status. But if they're out of status already, if they've overstayed, in that case, they may need a waiver if they've overstayed over 180 days. If they've overstayed over 180 days, that waiver, if approved, would allow them to go back to their country in time for the interview and then get the permanent residence. So that's where you're going to want to get legal advice to determine whether your spouse can qualify for this waiver. So Sextina, how long after marrying 10-year green card holder to get work permit and green card? So now, Sextina, how long after marrying a 10-year green card holder? Now, if you're out of status and you're married to a green card holder, unfortunately, you wouldn't be able to qualify for an adjustment of status. Generally speaking, unless of course you're married to a green card holder and you're applying for VAWA where that spouse mistreated you or abused you. But other than that, you would not be able to qualify for adjustment of status. Remember, adjustment of status is applying for permanent residence while staying in the US. And what that means is that you won't qualify for the work permit. Now, if you are, because it's the adjustment of status process that allows you to get the work permit while the process is pending. So if you're married to a green card holder, you're going to want to get legal advice about what your next move should be. It doesn't disqualify you from getting the green card. Please note that that's not what I'm saying. But what I am saying is your process is going to be different. And if you don't qualify for adjustment of status, then you wouldn't qualify for the work permit. Now, keep in mind also that I'm not providing personal legal advice. These are general answers, and sometimes these answers can touch on just scratch the surface because there are such complex issues. So that's where the personal legal consultation is going to be very important to make sure that you get the right personal legal advice to take the right action in your particular circumstances. But my goal here is to be helpful, to empower you with information. If someone is deported, will their U.S. citizen underage child be able to come home with them? So yes, if the child can go home with them and it's not going to affect their citizenship. Now, whether there are other issues involved, like custody issues or even child welfare issues, that's another matter. But if generally you're deported, it didn't affect the child, you just want to make sure that you stay unified with your U.S. citizen child, that child can definitely leave the country. As long as it's leaving the country with your child is not breaking any laws, like it's not taking a child away or violating a court order or something like that. But generally, a U.S. citizen child can be outside of the United States. You have to check with the country though. Like I know, for example, in Jamaica, you have to have, I believe it's a stamp of unconditional stay. It's kind of like the green card. If you're a foreigner that's going to stay there for an extended period of time and you want to work, go to school, it's important to check with the Jamaican government. If you're Jamaican, I don't know if you are, but that's just an example of some of the requirements in some countries. I have a question regarding spousal sponsorship. Does the citizen need to prove they can financially support a loan? I live in the US and we want to avoid me having to leave for any period because we have. So your spouse will definitely have to provide an affidavit of support to show that they can financially support you. But if they don't make enough, there is the possibility that if you find a co-sponsor, then that could also assist. If they don't make enough, then the co-sponsor could step in. It's kind of like a co-signer, but the co-sponsor would step in, show their income, and then be able to, you would still be able to be approved based on that. Now, Estefania. Sometimes the affidavit of support is complex and very technical, and so you want to make sure that you are properly guided through the process, that you get the advice you need to move forward with the process. Especially, I see here that you're saying you want to avoid leaving the country, and so I would want to know what's going on there. If your spouse is a U.S. citizen, how did you come into the country? Did you come in with a visa? Did you overstay? Or did you cross the border without permission? In the case that you cross the border without permission, you may not be allowed to go through adjustment of status. And so you want to make sure that you get all the comprehensive legal advice to understand the process and what you're getting into. How do we know when you need a waiver? Also, is it best to do so before not knowing if you need one, if that makes sense? So Danielle Shantz, definitely that's a valid question. Now, there are different types of waivers based on different types of issues. So there is what's called the unlawful provisional unlawful presence waiver. That is for individuals who have been here and their only immigration violation is the fact that they stayed here and overstayed and then overstayed over 180 days. And they will not qualify to stay in the United States and apply for permanent residence. They're going to have to leave and go to the embassy. But here's the catch-22. If they leave the country to attend the interview at the embassy, because of that overstay over 180 days, once they set foot outside of the country without an approved waiver, automatic bar. No green card, no visa, no re-entry into the United States. You're stuck outside of the United States. And what would happen is you would have to wait for your interview. You would go to your interview and then find out that you are denied because you don't have the waiver, and that you will now have to stay in your country and apply for your waiver, for the unlawful presence waiver. The provisional unlawful presence waiver allows you to stay in the United States, apply for the waiver, and then once it's granted and your appointment is scheduled at the embassy, you can take your approved waiver and go to your interview and not have the fear that you're going to be denied based on unlawful presence waiver. And at that point, I'm confident you'll be okay because at that point, you should only have unlawful presence as your only immigration violation, and the waiver forgives that. So that's with unlawful presence. But there are other issues. So there's misrepresentation and fraud. If you've been charged with that, then you're going to have to apply for an additional waiver, and that waiver is going to have to be outside of the country. If you have, say, misrepresentation along with an unlawful presence, you wouldn't be able to qualify for, you could still apply for the unlawful presence waiver, but what would happen is you would end up going to the interview at the embassy in your foreign country, and they'll say, great, you got forgiven for your unlawful presence, but you still have misrepresentation that you need an additional waiver for, and now is the time that you'll have to apply. In addition to that, you'll have to make sure you qualify for the waiver, because not everyone qualifies for a waiver. Usually these types of waivers, so misrepresentation, unlawful presence, they require you to have a U.S. citizen or legal permanent resident spouse or parent who will experience extreme hardship. Now, if you are in the United States and you qualify for adjustment of status, they do allow you to submit the waivers for misrepresentation in the United States. So you don't have to leave then. But the issue is, if you have more violations and unlawful presence and you don't qualify for adjustment of status, at that point you're definitely going to have to go to the embassy and then apply for the waiver, which is a pain and is frustrating. But that's the way it is when you have other immigration violations outside of unlawful presence. Now, waivers are complex. Waivers depend on what happened in your circumstances. And so that is where the consultation is going to be very important, because I wouldn't be able to tell you in this live whether a waiver applies to you unless I speak to you in a consultation. So very important, but I appreciate that question greatly, because in some cases, if you qualify for adjustment of status, or you even qualify outside of the United States, say for example, you've previously been deported, a waiver is often required, and unfortunately a lot of people don't know that until they actually get to the interview, which can, it causes delay, causes undue stress. So very important that you understand about waivers. Waivers are a way to get forgiveness for past immigration violations, or if you're inadmissible, to get it waived so that you can get your permanent residence. Can a case be reopened after 3 years after denial of green card through a U.S. child petition? So that's an uphill battle, and in a case like this, you probably want to just reapply. So sold by carry, that's where you're gonna need to schedule a consultation to determine. I would really be curious about why you'd want to reopen instead of reapplying. I mailed my application 90 days ago, still no receipt notice. I call USCIS, they said they don't have anything for me. I also checked the status of the money order, it was not cashed. What should I do? So Samantha, if you sent it by, you could check to see if it was delivered, because if it hasn't been cashed and they don't have any information, then it would appear as if they maybe never received it. And so I don't know if you've done this already, but if you haven't, perhaps check to see if it even got to the USCIS. If it did, it could be that they lost it in the mailroom. So, in a case like this, if they don't have it and nothing was cashed, you may have to just resubmit everything if it gets impossible and you can't find it anywhere. Now, keep in mind the information I'm giving you here is general information and it's not legal advice. Hi there, Zella Princessa. I'm doing well. Thanks so much for asking, and I hope you're doing well as well. So what if your spouse is a U.S. citizen and living in a different state? Will that be an issue in filing? Yes, so it could very well be an issue. I can tell you, yes, it's going to be an issue. But what I would say is it doesn't make it impossible for you to get permanent residence, but you're gonna have to make sure that you can convince this skeptical officer that your marriage is real, being apart. Because I can tell you it's gonna be an issue, because the minute you walk into the interview, if not even before you get to the interview, that officer is going to be very skeptical. They may even lean on the side of the fact that it's not a bona fide marriage, and they're gonna press into that issue. They're gonna ask a lot more questions about the marriage, and they're gonna want a very good reason along with a very good evidence that your marriage is bona fide. So it could very well be an issue, and if you can avoid it, do so. I do understand that sometimes couples, they have to live apart, especially during the pandemic when it was hard to find jobs. Maybe one of the spouses had to go outside of the state to maintain a job or to find a job, just to make ends meet. And so this is what you would have to address in your interview and perhaps even in your application. But get legal advice because it's also going to depend on what other types of evidence are you showing to show that it's bona fide. So very important that you get guidance, get representation through the process. Can my brother, who is a green card holder, file for me? So Renee Tomlinson, unfortunately, no. Siblings can't file for their siblings. So green card holder siblings can't file for their siblings. But when your brother becomes a U.S. citizen, he can file for you. Great questions so far. I really appreciate you all giving me these questions, and keep them coming. Small children, I came legally with TN visa. Okay, so you have small children, and I came legally with the TN visa. Okay. So Estefania, can you, okay, so I know we had mentioned before, how did you come? So you did come legally. Okay. So keep those questions coming. I really appreciate these questions. What is considered misrepresentation? So a lie. Any lie, if you've omitted any information, it's that simple. If you tell a lie, you omit information, or you provide misleading information, guaranteed that that is going to lead to misrepresentation or fraud. So for example, if you put on your application that you're not married to get the green card faster through your parent, when you know that you are married, then that's misrepresentation. So it is willful, a willful intent to lie, to omit, to mislead the officer for an immigration benefit. Okay, so Natasha, I missed my appointment date for my biometrics. I didn't get notice in the mail. So what should I do? So contact them and let them know, and they will schedule. They may reschedule. So Zella Princessa, you are welcome. So keep putting those questions in the comments. Now, while your questions continue to come in, I just want to let you know again that the information I'm giving you here is general information. It's not personal legal advice. And so you should not be taking action. This information is here to empower you, is here for you to understand to an extent, because it is complex. These are complex issues, but for you to understand to an extent what this process looks like. But when it comes on to taking action for yourself in your own case, highly recommend that you first schedule a consultation. And you can do that by going to the link in my bio. It's going to take you to the website where you will see a phone number. At the top of each page, you'll see a contact form where you can quickly fill it out, and a scheduling coordinator will get back to you. And scheduling coordinators are out tonight because it is a holiday. However, when they are in 9:30 a.m. to 11 p.m., you can have the chance to speak with one through the online chat as well. So if someone did a misrepresentation for a visitor visa, will it affect that person when they apply for a green card? Certified Bless, I appreciate your question. Yes, absolutely. Misrepresentation leads to a lifetime bar. That means you will be barred from any green card, any future visas, any re-entry into the United States for a lifetime, unless you qualify for a waiver. And only certain people qualify for the waiver. Only individuals who have a U.S. citizen or legal permanent resident spouse or parent who will experience extreme hardship will qualify for this waiver. And what that means is that if you are applying through a sibling, for example, and you don't have any spouse, you don't have any parent here, that's going to cause your green card process to be dead in the water, because you have no qualifying relatives to get forgiveness for that misrepresentation. And even then, while, for example, in my case, I work very hard for my clients to increase their ability to succeed in the waiver process, it is never guaranteed. So even if you have this qualifying relative, some people don't have anything to lose. It's their only option. But it's not guaranteed to be approved. And so that means that if it's not approved, it's dead in the water. No green card, no re-entry, no visa. So make sure that you avoid any kind of omission, any kind of lies, any kind of misleading information. in your application to avoid these devastating consequences, because it can be quite devastating. So keep putting those questions in the comments while I'm here. I really appreciate your questions tonight, and I'm coming with a different approach. I'm letting you lead the conversation by putting your questions in the comments, and I'm just here to answer your questions. It's my way of providing information that you want, that you care about. So go ahead and put your questions in the comments, and I will answer your questions. So I am also going to be on tomorrow night at 9:30 p.m. Eastern as usual. So this is not the end of the conversation. Now, even though tomorrow I'm going to come with a topic, it doesn't mean that you can't ask your questions. Actually, in every single live, I prioritize your questions. And so when I come back tomorrow at 9:30 p.m. Eastern, or around 9:30 p.m. Eastern time, you should feel free to put your questions in the comments so that I may answer your questions. I really recommend that you do a consultation, because that is where you're going to get the personal attention, personal advice that you need. While the information I'm giving you here is very general, it's only meant to be information for you. It's not meant for you to act on, or to go and do anything by yourself. I don't recommend that, but I do understand that information can empower you. So it was my pleasure to be here tonight to answer your questions. I don't see any more questions coming in, but I hope to see you tomorrow night at 9:30 p.m. Eastern, or in a consultation. Just go to the link in my bio, it'll take you to the website where you'll have all the information to get in touch with the firm and schedule. Okay, so can you reapply in the future if your visa was revoked? The waivers available doesn't match scenarios when someone anonymous is lying on you. So you can apply for, you may, that's Daniel Shantz, it depends. Now, if they're lying on you about something, but they have revoked your visa because they're taking the information as credible information, then whether you're going to get that visa back based on applying again is going to depend on what the information is. And if that information is very damaging to you, then it's going to be difficult, an uphill battle to get another visitor's visa. In addition to that, if you want to apply for a green card through, of course, a qualifying employer or relative, then it may even affect you there, just depending on what they have on you. What is it that they are accusing you of doing? So that is where you'll definitely have to get legal advice to discuss what was the lie, because if they revoked your visa, they are definitely taking that information very seriously. So legal advice, very important in this case. All right, everyone. So thanks so much. Keep an eye out for videos. I often do short videos, entertaining videos, of course, to give you information about your possible options. Thanks so much for the love. I appreciate it. To give you possible ideas about what may be some solutions in your case. I help clients to get their permanent resident status, as well as a work permit where they qualify. And so if you are in a situation where you want resident, you want the work permit, and you're here, you've overstayed, you can definitely look at your options with me. Who's a qualifying employer? So when I say qualifying employer, I mean an employer who qualifies to apply for your permanent residence. Same as a qualifying family member who qualifies to apply for their relatives' permanent residence. So that's what I mean by qualifying. So thanks everyone. Have a great night. Thanks for the love. Thanks so much for the questions. These were perfect questions. I will be back tomorrow night at around 9:30 p.m. Eastern time, where I will continue to take your questions, and I'll come with a topic as well to talk about. Have a good one, guys. Bye.